I'm Dean of the School of Law at Emory University, and it's my pleasure to welcome you to our annual Martin Luther King lecture. You will realize that this is now February, our lecture is delayed. We wanted to delay from the traditional date in order to give an opportunity to have participants both in person and online. And I'm delighted we're able to do that this evening. To see all of you in person here in Tall Auditorium is one of our first major events since the pandemic hit us 2 years ago. And I have to say, behind this mask, I am beaming that you're excited at the fact that we're able to be here tonight, hear from our distinguished lecturer. It's really quite meaningful for us as an academic community. We like to know and to see each other's faces as we get together and think about some of the most important issues facing our society. I want to thank as well those of us who are participating online. It is one of the advantages of the pandemic. We realize how we can open up the law school and the university more broadly, the public debate and discourse, by offering the alternative, the option to participate remotely. We're delighted that those of you who are online have chosen to participate this evening. We will soon hear from Professor Darren Hutchinson. He is our inaugural John Lewis Chair in Law. His position was made possible by Darren, who also supported the creation of a new center for civil rights and social justice. And we are thrilled by the generosity of so many who have allowed us to recruit this wonderful law professor to our community to allow us to engage with these important topics and have an impact beyond the law school and university and the community as a whole. This is also a special occasion for us because we're joined by both the president and the provost of the university. The provost, Ravi Balakonda, will be actually introducing Professor Hutchinson in a moment. But first we'll hear from President Pendex. I will say it's been wonderful for me as a law school dean to have both of their strong support for law school and the real sense of what a law school can mean, not just for students who graduate from the school and go on to serve their clients in society, but also for the way in which the law school could be a place of public discourse and debate about the key issues facing our society. Well, I welcome President Pendex to the stage first. He has a wonderful career in higher education and academic leadership. He's gesturing to me to cut back on the introduction. I'll just say he came to Emory in summer of 2020, drawn by the university's mission to create, preserve, teach, and apply knowledge in the service of humanity. And we're honored to have him here this evening.
Thank you, Dean Babinski, and good afternoon, everybody. It's great to see everybody in person. And it's an honor to welcome you here, those who are participating remotely, to Emory University's 2022 Martin Luther King Jr. Day lecture. I'm grateful we could be joined. I don't know if Justice Sears is able to be with us today. Justice Sears, it's great to see you in person. Thank you. Justice Leopold Sears, who is also Vice Chair of the Emory University Board of Trustees. It's so great to see you. Thank you so much for everything that you do. Thank you. We're also joined by Emory Law students, faculty, graduates, and supporters, including the generous donors who created the John Lewis Chair for Civil Rights and Social Justice, which is held by today's featured speaker. Thank you all for your support for this important chair. As the Dean mentioned, this lecture is supposed to take place in January during Emory's King Week activities, the celebration of Dr. King's life and his profound legacy today. And that legacy of leadership and teaching that has transformed our nation lives on in today's keynote speaker, Emory Law Professor and the inaugural John Lewis Chair for Civil Rights and Social Justice, Professor Darren Hutchinson. Professor Hutchinson has written, there are a lot of different levers to push for social change, and you cannot give up on any of them. Through his scholarship, lectures, and writings, he has observed that progress requires us to lead change through action by pushing those levers, but also to build action on a strong foundation by understanding our history, seeing clearly who we are and why our society has taken its current form, looking back so that we can move forward. Because our history holds compelling lessons throughout our nation's long struggle towards racial and social justice. For every victory, there has always been a pushback. For every movement demanding progress, a counter movement to challenge that progress. Today, we're going to hear more about that struggle from Professor Hutchinson, from his scholarship, his learning, and his teaching. Grappling with racism remains at the center of our national conversation, including today. I cannot imagine a more important time to be having this conversation or a more distinguished and insightful scholar to lead. As you know, Professor Hutchinson is the director of the Emory University School of Law Center for Civil Rights and Social Justice, which was made possible just last year through a big investment by the Southern Foundation, which is represented today by Rita Green and Nikita Trevor. My deepest thanks. Deepest thanks to both of you and to the Southern Foundation for supporting this exciting and crucial endeavor. This new center is a hub for interdisciplinary scholarship, research, teaching, and community engagement, with the goal of improving the lives of those who have felt the sting of social injustice, the impact of violations of their civil rights. It empowers our faculty, students, and community partners to amplify their work in these critical areas and for these goals. Universities are meant for moments like this, to stand in the midst of unfolding history and support vital new ideas and challenging paths of inquiry on the path to action. I'm so glad we could be together here today to hear from Professor Hutchinson and to gain knowledge and understanding through this crucial dialogue. At this time, I'd like to turn the program over to our Provost and Executive Vice President for Academic Affairs, Bobby Mellon.
Thank you, President Fenn. It's so thrilled to be here. Tonight's lecture is a commemoration of Dr. King's legacy, and also Congressman Lewis's long fight for what is just. I'd like to consider it a celebration too, because at Emory, President Fenn's leadership and before, we were working hard towards a future that is true to Congressman Lewis's vision for a fight for a stronger, so that we can fight for civil justice and social justice. In a recent talk that Professor Hutchinson gave at the Chicago Theological Center, Professor Hutchinson shared these words of Congressman Lewis. I quote Congressman Lewis: "Freedom is not a state, it's an act. It is not some enchanted garden perched high on a distant plateau where we can finally sit down and rest. Freedom is the continuous action we all must take, and each generation must do its part to create an even more fair, more just society. The work of love, peace, and justice will always be necessary until their realism and the imperative takes hold of our imagination, crowds out any dreams of hatred or revenge, and fills up our existence with their power." This quote is from a book by Congressman Lewis entitled "Across That Bridge, A Vision for Change in the Future of America." It's an apt quote for Professor Hutchinson to choose, as he's the inaugural John Lewis Chair for Civil Rights and Social Justice and the Director of Emory School of Law Center for Civil Rights and Social Justice. From this quote, we can gauge a lot at a glance, both about Congressman Lewis and his long quest for freedom and justice, as well as Professor Hutchinson and the center he leads. It says that freedom is a verb. It requires action on all our parts. Our Center for Civil Rights and Social Justice is located in the School of Law, where its focus on teaching, research, and community engagement is relevant to all of them. It says that the fight for freedom is a long-standing one, and maybe longer still, that freedom is the work of generations, not just for one generation. It speaks or to our deep commitment to civil rights, social justice, and Professor Hutchinson, his leadership, and the center itself. It also says that imagination will be required. We have imagination in abundance here. Students, faculty, and community partners will bring this imagination to the fight against racism. It also says we must come together in love, peace, and justice, and leave behind hatred and revenge. We believe in and are committed to each other in this work, heeding the wise words and legacy of John Lewis, and celebrating our ability to approach them in a new way, thanks to Professor Hutchinson and the Emory School of Law's Center for Civil Rights and Social Justice. So tonight, we look forward to hearing from Professor Hutchinson, and his talk is titled Anti-Racism, Fighting Backlash and Building Justice. So just last year, we were able to name Professor Hutchinson the inaugural John Lewis Chair of Civil Rights and Social Justice and launched the center in September, thanks to the gifts of donors like you and the Southern Company Foundation. Professor Hutchinson came here to Emory in July of 2021. I had a conversation with him before he became in spite of him. I'm just kidding. So it was wonderful. From the first minute I spoke with him, I was very hopeful that he would join us and at the University of Florida, 11th College of Law, where he was previously serving as the Raymond William Early Eminent Scholar. Prior to that, he served at the American University, Washington College of Law, and the Southern Methodist University, Darren School of Law. Professor Hutchinson received his JD from the Yale Law School and BA from the University of Pennsylvania. Following law school, he was a litigation associate at the New York City office of Perry, Gottlieb, Steen, and Hamilton. He also served as a law clerk for the late Honorable Mary Johnson Lowe, U.S. District Court of Southern District of New York. At Emory, Professor Hutchinson's work focuses on civil rights and social justice, crossing multiple academic disciplines as he interrogates inequalities and multi-dimensional concepts. Professor Hutchinson, on behalf of everyone here tonight and the entire Emory community, thank you for your work, and we look forward to your answers. Welcome.
Good evening, everyone. I want to first start by thanking Dean Kuczynski, President and Provost, for the kind words they expressed about me. I can say that in 20 plus years of teaching, I've never had such warmth reading my work on social justice. So I'm continually reminded that I made the right decision to come to Emory. I also want to thank all of you who are attending, including a lot of our students. And those who are watching on Zoom. Your participation is inspiring to me as a scholar and as a teacher. I'm honored to have the privilege of sharing my thoughts regarding social justice and to celebrate the life and work of Dr. Martin Luther King with you. I still remember as a child, somewhere right before kindergarten, reading a book about Dr. King. It was age appropriate. And I was fascinated and also horrified by the content of the book at the same time, simultaneously. I never thought at the time that I would dedicate my books to this topic, but I guess my emotional reaction at the time signaled that it was in me. Although many things have changed since King's death, we still face so many pressing issues. Although blatant bigotry has been somewhat and largely removed from our laws, the law continues to facilitate and to create systemic racism. Now, as a broader definition, when I say systemic racism, I'm referring to laws, policies, and other social practices or beliefs that cause or reinforce racial inequality. Right now, there's a requirement for another definition. When I talk about racial inequality, I mean measurable racial differences regarding important social resources and also penalties, such as housing, education, employment as resources, police surveillance, police brutality, and incarceration as penalties. All of these concerns, racial gaps are persistent and strong. These disparities result from historical discrimination, inherited inequality, and ongoing practices that, regardless of intent, result in the preservation of racial inequality. And the law is a central instrument of systemic racial inequality. It is imperative that those of you who are lawyers and future lawyers learn how statutes, regulations, and court doctrines foster systemic racism. Currently, legal scholarship and teaching on the subject of systemic racism is under a broad coordinated attack. The battleground, however, is not in law schools, it's in K-12 public education. Several states have passed laws that bar instruction regarding critical race theory. And if you examine the anti-critical race theory policy more carefully, they actually are barring instruction regarding historical racism. My discussion this evening will focus on the content of critical race theory. Now, I wrote that for you. First, I'm going to discuss the general themes of critical race theory, which is the leading anti-racist legal scholarship. I will then argue that Dr. King embraced many of the central themes of critical race theory in his advocacy. In other words, he was a critical race theorist before we even had the terminology of critical race theory. Next, I will argue that advocates of social justice should not view the anti-CRT attacks in isolation from other contemporaneous actions that collectively represent a counter-movement to anti-racism. In other words, I hope to convince you that the attacks on CRT are part of what I refer to as an anti-racism movement that began as a backlash to the 2020 election and to Black Lives Matter massive global mobilization following the murder of George Floyd. Finally, I recommend actions that social justice advocates can take to counter anti-racism. So first, let me turn to the things of critical race theory. A lot of people have no idea what critical race theory is. You wouldn't unless you were in law school or in some graduate program that had instruction on critical race theory. Nevertheless, critical race theory has received widespread condemnation in society as a result of blatant misrepresentation of the content of the subject. So, then what is the reality behind this? Well, critical race theory became an organized body of legal scholarship in the late 1980s. Many of the original members of CRT were students at Harvard Law School who had taken coursework with Darren. Many also participated in the critical legal studies movement, which produced numerous articles demonstrating how legal rules reinforce social hierarchy. The goals of critical race theory were summarized succinctly and powerfully by Kimberly Williams Crenshaw in her introduction to an anthology called Critical Race Theory, the Key Writings that Form the Movement. Crenshaw is famous for her research on intersectionality, specifically the intersection of racism and sexism. In many respects, she's a household word. People know who she is, they know what intersectionality is, and they can make those connections. In the introduction to the Key Writings that Form the Movement, Crenshaw argued that there were two primary goals of critical race theory. The first goal was to demonstrate the limitations of traditional civil rights. Traditional civil rights is founded largely on the notion that our laws should be racially neutral, right? And more specifically, that there should be facial neutrality, meaning a law that has a racial classification on its face and triggers greater scrutiny by the court, or is a statute that should be invalidated. In order to demonstrate the limits of formal equality, critical race theorists, or these early critical race theorists, argued that substantive equality, right, defined as the racialized effect of laws and policies, or the conditions in which people of color, racially subordinate individuals live, is a better form of equality, and it's one that courts and legislatures could apply. They argued that this approach to inequality would do more to eradicate racial inequities that I discussed earlier. So, with this particular tradition of civil rights, the critical race theorists were promoting a substantive notion of equality. Right? So that's point B. The second goal that Crenshaw discussed was that critical race theorists sought to make a racial intervention into pre-existing progressive legal scholarship. And the one form of progressive legal scholarship that they discuss in their works is critical legal studies. And so, the critical legal studies movement was formed to conduct research and publish articles demonstrating how the law was responsible for the perpetuation and creation of social hierarchy. So hierarchies around wealth, hierarchies around sex, and race. However, as a solution to these problems, many but not all members of the CLS movement engaged in what was called rights trashing, or a very strong condemnation of rights. They argued that social justice advocates should stop seeking rights because rights, like the law generally, are indeterminate, meaning they don't have a predictable fixed outcome. Right? That's because the law is malleable, there's a lot of discretion with respect to how judges can interpret rights. It's easy to manipulate a factual scenario to create an outcome that perhaps progressives did not anticipate with respect to application that they will rule. Now, critical race theorists actually agreed the rights were malleable, that they were indeterminate, but they argued that rights were nevertheless valuable. Why? Because they have historically inspired marginalized groups, including people of color, to organize to contest inequality. Also, that even though rights are limited, they have generated some positive change in society. Right? So, this next thing is what I call dual consciousness. So, critical race theorists had a dual consciousness with respect to the law and rights. They agreed that the law perpetuated social inequality, but they are committed to using the law to create more just outcomes. Right? And that's dual consciousness seen in a lot of the earlier writings on critical race theory. Another trend in critical race theory is adherence to race consciousness for remedial purposes. So governments using race in order to provide more justice. And this is directly counter to the notion of formal equality. Because remember, as I said earlier, formal equality expresses the belief that any classification based on race or other prohibited categories is inherently unconstitutional. Critical race theorists generally support race-conscious remedial action that is designed to ameliorate inequality. So this would include things like regulation, employment and higher education, racially drawn districts that protect the voting power of Black voters, race-based school assignments in K-12 to prevent racial isolation, and to some extent, reparations for folks who suffer from slavery and Jim Crow. A final thing is intersectionality, which I mentioned earlier. A lot of folks are familiar with that, but critical theorists have argued that forms of subordination are mutually reinforcing and have condemned efforts to essentialize identity because essentialism obscures differences created by intersecting or multiple forms of oppression. And they argue that in order to have complete racial justice, anti-racists need to deal with things like sexism, which affects the problem. Heterosexism, which affects LGBT persons of color. Wealth inequality, which affects poor people of color, and other forms of accommodation. This is so, they argue, because subordination, various forms of subordination, intersect with racism, and this informs the unequal status of persons of color. One clear example of this is the wealth status of women of color. Women of color are the poorest segment in the United States. And that's caused by racism on one hand, and also sexism. And so if anti-poverty concerns are central to anti-racism, which they are, then feminism should also include anti-racist advocacy. So moving on to the next section, I want to show that Dr. King was one of the earliest critical race theorists. And if you look at some critical race theory, the writers have actually referred to Dr. King and his liberation theology message as an inspiration for their work. And you can find things of critical race theory in a lot of writings and speeches by King. And as a shorthand, for those of you who don't want to go and look up all of the things he wrote, you can literally turn to one interview and find a lot of these things. And that interview was conducted by Alex Haley, who is the author of Fruits, among other books, who conducted an interview with King in 1965. And Alex Haley has a blog, alexhaley.com, where you can go to and pull up this interview. During this single interview, King expressed commitment to many of the themes of critical race theory over 20 years before the origins of this body of research formally described as critical race theory. So first, in this interview and in other places, he criticized traditional civil rights and demanded substantive justice. All right, so in the Haley interview, he criticized the Civil Rights Act of 1964. Now, King's activism was central in getting the passage of the 1964 Act. And the 1964 Act is undeniably important, right? So it has provisions that ban employment discrimination based on race, sex, and other factors. It bans racial discrimination in places of public accommodation. So it's a statutory reversal of places of servicing. And it also bans racial discrimination in federally funded programs. And this part of the statute becomes very important in catalyzing school desegregation because all public schools are funded in part by federal funds, and the continuation of discrimination on the basis of race would mean that those schools could potentially lose their federal funding. And the losses would have been very substantial. Despite his role in the passage of the legislation, King told Haley that the law didn't go far enough. He argued that it needed to do more to protect voting rights, viewing democratic participation as essential to a social justice mission. He particularly noted that despite the passage of the Act, literacy tests are still legal. He argued in favor of something described as universal voter registration. So if you reach a certain age, you're literally registered to vote, all right? And we see some members of Congress and state legislatures demanding such laws today. He was adamant that we needed that as a matter of federal law. Now, notice though, later in that same year, 1965, Congress passes the Voting Rights Act. Okay, so continued advocacy meant passage of the Voting Rights Act, which voting rights scholars have said is the single most important legal change that enhanced political participation among persons of color, even more important than the 15th Amendment. Because despite the ratification of the 15th Amendment, it wasn't until the Voting Rights Act was passed that people of color could participate in the political process nationwide. Right? So there were some states in the north and the upper Midwest where people of color could routinely vote, but in the southeast, southwest, and including in parts of California, people of color were not allowed to vote due to many things like literacy tests, poll taxes, etc. He also wanted more enforcement of civil rights, right? As Chief Justice Marshall says in Marbury versus Madison, rights are meaningless without a remedy. So King was basically picking up on this point, needing the Department of Justice to come in and enforce rights, because without remedies, they were meaningless. More importantly, he wanted to see laws that addressed poverty. And he said that the Civil Rights Act of 1964 only benefits middle and upper class blacks. Right? It doesn't do anything to address the plight of blacks who live in ghettos. Right? So today we would call that concentrated poverty. But the point is the same. There is no element of economic justice that's blatantly a part of the legislation. The only part is employment discrimination, which goes towards economic reality. But again, middle class people were more able to avail that provision because they would have an educational background to allow them to challenge discriminatory employment practices. Much like Black Lives Matter and CRT criticized law enforcement, right, saying that we needed a federal remedy that dealt with inaction in the southern states with respect to violence, private racial violence against people of color. And this is very important because the 14th Amendment itself, the Equal Protection Clause, was actually ratified with the goal of incentivizing or punishing southern states that failed to protect the newly freed slaves from violence. Okay, that's what equal protection actually means. The literal meaning, this narrow definition of equal protection in the 14th Amendment, it's a call for equal protection against harm. All right, and so King was reiterating this need in 1965. He also observed that Brown versus Board of Education was a failure due to massive resistance. And noting that in 10 years after the decision was rendered, fewer than 1% of Black children in the South attended schools with whites. A lot of that changed after 1965 with the passage of Title VI, the ban on racial discrimination and federally funded programs, and also the Supreme Court doing much more to enforce the Brown mandate after 1964. So there's a rapid desegregation that occurred after 1964. And the South became the most desegregated portion of the society with respect to public schools. I'm almost done with King as a paragraph there, but it takes time. In the Haley interview, he described himself as militantly nonviolent. And of course, Haley says, what do you mean by that? What is that all about? This is dual consciousness here. King says a strong man must be militant as well as moderate. Right? And that is the critical race response to CLS. Yes, we can realize that the law is a failure in many ways, but we're still going to rely on the law. And that's what he's saying here. You have to be committed and defiant, but also you have to accept that things are not going to change in the fashion that you want them to. It'll be slower, which is why you need continuous commitment to social justice. King also supported race consciousness. Now, this is an area that really needs to be focused, because there is a concerted effort to take his speech at the March on Washington. The part of it which talks about him wanting his children to be judged by the concept of the character, not the color of their skin. Individuals and institutions, including members of the Supreme Court, have said that this means no affirmative action, no race consciousness. And in a very controversial decision called Parents Involved in Community Schools, in which the court struck down race conscious school assignments, Justice Roberts went at length to say that his approach, which basically would cause resegregation, was more consistent with the civil rights movement. And that triggered a response from participants in the civil rights movement and said, this is not what we want. King, despite the perverse use of his words, actually spoke about race conscious remedies a number of times, right? One of those things he addressed was reparations, race conscious reparations. So in this same interview, he specifically proposed a $50 billion package of federal investment in Black communities, which would be $1.4 trillion today. He also, when asked about White resentment to this proposal, said that if Americans can underwrite its allies' enemies, referring to the Marshall Plan, it can certainly afford and has a much greater obligation, as I see it, to do at least as well by its own no less needy countrymen. He also endorses preferential employment of people from disadvantaged backgrounds. There's another policy that he endorsed in practice of the civil rights movement called Operation Breadbasket. And what this meant was blacks would boycott companies that did not hire them. Okay? In negotiating an end to the boycotts, Operation Breadbasket demanded quotas representing the proportion of blacks in the local population. All right, and that is something that the Supreme Court adamantly says is inconsistent with equal protection. It's also something that most critical race theorists will endorse. Finally, I just want to do a little bit on intersectionality. Now, King did not discuss feminism. He didn't discuss LGBTQA rights. He nevertheless discussed the plight of people who are not Black, particularly talked about Latinos, Latinx populations. He also discussed Anti-Semitism, and he discussed poverty to a great extent. And I argued that his willingness to see behind just race meant that, in contemporary terms, he would probably embrace intersectionality. All right, and in fact, there's this famous quote by him in the letter from Darren jail, in which he talks about inequality somewhere in regard to all of us everywhere. All right, and that is literally a hallmark of intersectionality, that forms of discrimination and subordination are mutually enforcing with racism, and that critical race theorists can't be silent on other forms of discrimination and claim to be advocates for communities of color, because they're affected by these other forms of discrimination as well. And later, Coretta Scott King would argue that he would have supported LGBTQA rights in a modern context. There's a lot of question about whether LGBTQA rights should be protected by the Constitution. This was in the early 90s. And a lot of folks went to her saying, hey, what was your husband plot? And the goal of that was to get them to hit anti-racism against the gay rights movement. And she said, citing to the language, that he would have supported gay rights. So let me move on to what I view as anti-racism. All right, so I encourage advocates of social justice not to view the critiques of critical race theory in isolation from other recent coordinated attacks against anti-racism. This counter-movement activity became heightened following the Black Lives Matter global mobilization in 2020 and the presidential election in 2020, which led to Trump's defeat. There are four components to this counter-movement, which I described again as anti-racism. While the Black Lives Matter backlash is easy to understand as a moment of anti-racism, what about the presidential election? So that requires some deeper elaboration. All right, I argue that President Trump became a symbol of white supremacy and racism. Right? In some speeches, I've described him as a mascot for white nationalism and white supremacy. Why? Because of the carnival atmosphere that existed in his rallies, where he would stand on stage and promote a number of racist ideologies. Even before he was elected president, he was found guilty by the Department of Justice for engaging in housing discrimination. He infamously supported the death penalty for the Black and Latinx youth who were accused of raping a white woman in Central Park. And the connection to race here, it requires some understanding of history of the death penalty race. So the court has said that application of the death penalty to a defendant who commits a rape without death occurring is unconstitutional, right? It's a deprivation of due process. The case that does that, by the way, is Poker versus Georgia. So it emerged from a Georgia prosecution. In that case, justices wrote opinions that went beyond due process. They also talked about racial discrimination. And the stats were, when the death penalty was legal for rape, 90% of the men charged with rape, executed for rape were Black. 100% of the victims of rape were White. Right, so those stats are already very dramatic, right? They're even more dramatic when you think about the demographics of rape, and those are the same today. In most instances, rape is intraracial, meaning the victim and the assailant are of the same race. Despite this, we have an almost singular focus on Black male defendants and white women victims. I should say alleged victims, because a lot of the trials that led to guilty verdicts really were miscarriages of procedural process. And so that's a little bit of history about our state with respect to the death penalty. Trump inserted himself into that history when he bought those ads in all of the New York newspapers calling for the return of the death penalty for rape. I could talk about a lot of other things, the Muslim ban, launching his campaign, criminalizing Mexican Americans, his rescission of Obama's executive order that required local governments that receive federal funds to ensure that people of color have access to housing in the suburbs, right? Saying that this would destroy the suburbs, and also when he made the announcement of it happening, he encouraged suburban women to pay attention to the articles on the subject. And I think that was really white suburban women. He was trying to get at this notion of people of color committing violence against whites. All right, so that's why I think his election represents, in some ways, a triumph for anti-racism. You can also look at the demographics of who voted who to get this as well. So need more elaboration than I just did. So what's the content of this county? First is discrediting the election. So if Trump's defeat represents a triumph for anti-racism, then there is this impulse to discredit what happened. That started even before the election when President Trump's continuous tweets about mail-in ballots being fraudulent, even though he voted on mail-in ballot in 2016 and in 2020 in Florida. So that became a concern. There are also lawyers who were state attorneys general or who were private attorneys representing individuals filing frivolous lawsuits claiming that there was fraud in the election. And as you saw, courts rejected that in almost every instance. Probably the most dramatic display of opposition to the election occurred on January 6th with the Capitol riots, where numerous people were killed. And even today, long way away from the election, there's still opposition to investigating these crimes by some members of Congress. All right, so that's the first category. The second one is passing restrictive legislation. So almost immediately after the election, a friend of mine literally whispered at me during a meeting, they're going to use this election results to say, to argue that we need stronger election legislation. And what they're going to do is use that to make it hard for people to vote. Lo and behold, that's what happened. So this friend was really good at English. So someone I was thinking for us, to run against that. And there's an immediate outcry by social justice advocates to the legislation, many of them describing it as Jim Crow 2.0. And that received a backlash. Like, this is not Jim Crow. We say this, it applies to everyone mutually. But that's how Jim Crow, in many respects, works. So the voting laws applied to everyone. There was a predictable disparate impact with respect to poll taxes and literacy tests. And there was some discretion in terms of allowing some voters who failed the literacy test to actually vote. Right? And what that meant was white local administrators would allow whites who failed the literacy test to vote, but not allow people of color to. In preparation for this talk, I looked up Alabama's literacy test that existed before the Voting Rights Act. It had 70 questions about civics. Some of them I couldn't answer as a constitutional lawyer. Like, what is this madness? They were phrased in crazy ways that made it difficult for people to get answers, and I swear they probably gave some people the answers people could test. So that was madness. The Voting Rights Act considered that. Chilling anti-racist advocacy. Another thing we saw were laws designed to expand the definition of riots, right, which would give police officers greater latitude to disrupt protests. And I want to recommend to you an article on lawfare. It's a blog run by law professors and lawyers who do work on national security. They have a great essay on these anti-protest laws that have been popping up across the country. And some of them, they do a couple things. One is they expand the definition of riot, right? And they also enlarge the penalties. So in Florida, the penalty penalties for rioting have gone up to now 5 years. Okay, and if it's a riot with 25 people or more that endangers safe movement by a vehicle, whatever that means, it's punishable by up to 15 years of incarceration. So this is really serious. The final move, part of this anti-terrorist movement, is the chilling of the intellectual basis for the anti-racist movement. And CRT is really the permanent target there. Even though the battleground is a location where CRT isn't even taught. That's why I don't think this is just about CRT, it's anti-racism. They're banning CRT in places where it doesn't exist. But if you look closely, what they are banning is things like teaching that racism is anything other than individual bias. So if a teacher wants to talk about racism, that's how they have to talk. That's for this policy. All right, so they couldn't talk about systemic racial inequality. Some states, including Georgia, are considering legislation that would make it a crime to engage in instruction that makes any child feel guilty about their race, sex, or class, okay? Which is very interesting. And again, this shows us that this is my whole series of anti-racism. All right, oh, thank you. So I'm ready to wrap up. With some recommendations, I hate giving a talk that criticizing doesn't lead you to some optimism. So the first thing I think we need to do is look at history. This is a playbook that's been repeated throughout history. We all know about the struggles to attain suffrage for people of color and for women in this country. It's been done before. We have to respond in the same way. With activism, with litigation, with petitioning state legislatures, etc. Okay? Anti-racist activism has also been attacked historically. Right? Reverend Birmingham jail, which I quoted earlier. Why was King in jail? For disobeying an injunction against him holding a protest in Birmingham. Right? Which blatantly violated the First Amendment. There's just no argument that it violated the First Amendment. The court, in a case called Walker v. City of Birmingham, held that he still had to serve criminal contempt for violating a judicial order, even if the order was unconstitutional. All right, and so that's why King was in jail and wrote that letter. There's also during World War II, there's a lot of research on this. People of color, were, more specifically blacks, were the group that was most arrested for violating sedition laws. All right, what were they protesting? Racism. And trying to reveal the hypocrisy of the U.S. fighting World War II under this theme of responding to tyranny and racism and anti-Semitism, while racism thrived in the United States. There are more blacks arrested than German Americans who were loyalists to Hitler, right? During World War II. And obviously, the theoretical content of anti-racism has been written throughout history. Right? Abolitionist literature was banned from being shipped in the U.S. Postal Service, which is incredible. Today, I like to point out that a lot of texts that are anti-racist have been banned in prisons. Most notably, Michelle Alexander's The New Jim Crow. Right, so materials that will help inmates understand better their situation with mass incarceration, presentations are banned. All right, but how do we respond to this? Civic engagement, protest, and for you lawyers and future lawyers, they're creative thinking about litigation. All right? The First Amendment can respond to a lot of this stuff, and courts have already invalidated a number of the anti-racist statutes. The First Amendment can also be invoked to respond to the policies banning frivolous theory in Cambridge schools. Right? The court has held that we have the First Amendment right to access information and also to speak. So the First Amendment is more complicated than just being able to speak. And the court has held, at least under the 14th Amendment, that restricting the information that students can receive in school can violate substantive due process. The case I have in mind is where the state of Nebraska banned foreign language instruction to all students who had not reached the 8th grade. What was behind that? They thought that only learning how to speak English would create a cohesive, loyal society to the United States. And the Supreme Court said, no, that's not what you can do. That is good law today. Another thing I want to focus on is equal protection legislation. All right, the anti-critical race theory laws, by virtue of the legislative history and debates about these laws, seem to be designed to protect white children from feeling guilty. But that violates formal equality. How can you pass a law that is designed to protect white children from feeling guilty? That strikes me as a quintessential equal protection violation. And what these advocates seem to mistake, however, is the goal of critical race theory. Critical race theory opposes white supremacy, not white people. There's a conflation of white supremacy with white by the advocates of the anti-Semitism legislation, right? Which I think we need to unpack and call them on, right? Simply being white and hearing about history and ongoing racial inequality, I have found in my classes is inspiring. Students say, hey, I'm going to go out there and use my life to make a better society. It's inspiring. When I read about King as a child, I wanted to do something better in society. And I think that many people respond the same way today. So again, we have to be creative. By the way, if you're 18 and older, which all of you seem to be, guess what? I'm not going to tell you to vote for it, but here's the thing that you can follow. If the candidate supports legislation and policies that are counter to social justice, don't vote for it. Just don't. You should decide your heart and ask yourself why you're voting for that person. Right? And this doesn't matter about parties or anything. This is about making an informed decision and one that you can justify and live with. Right? And I think that a lot of you would not be able to live with a decision that promotes social injustice. All right, and with that, I'm going to close. Thank you so much. I think we have time for a couple of questions. Yeah, if you have questions, always remember. Oh, here we go. Can you go to the mic so the people on Zoom can hear you? Or if you don't want to.
So throughout your talk, one of the things I was really thinking about is the ways in which a lot of people will kind of reduce racial disparities to kind of a byproduct of class or economic injustice. A lot of people would say or assert that racism, the more salient detail there is actually class. And I was wondering how you would characterize that.
Right, so the question is, a lot of folks would respond to racial inequality and with respect to the social resources that I pointed out as being a product of class, and how that responds. Well, being an academic, I like to respond with data. So One thing that social sciences have demonstrated is, or are really about, is this concept of concentrated poverty. So not only being poor, but living in a neighborhood where most people are, right? And what they have found is a couple of things. One, living in concentrated poverty is worse than just being poor, right? Because the neighborhood has a lack of resources, it's higher crime, and the schools are poverty schools, they're failing schools, or low quality education. And the housing stock is not good. They have also found that people of color are more likely to live in concentrated poverty than whites. Okay, so we're holding poverty as a constant here. People of color, due to housing discrimination, are more likely to live in the conditions that social science research demonstrates is the worst kind of poverty, the most debilitating kind of poverty. That alone tells me that race matters, even when we're talking about poor people. And I would also cite research by UC Berkeley professor Kiara Bridges. She actually wrote an article on this. We need to stop thinking about racism as really poverty discrimination, or that racism against poor people is the only valid racism. And she talks about health disparities that are consistent among people of color, even those who are wealthy and have insurance and go to the doctor, etc. And in particular, the mortality during delivery for Black women is higher than any other group. And wealthier, upper income Black women have the same disparate rate of death. So those are just two ways I would respond. Clearly, poverty is an issue that is something that anti-racists should think about, right, for the mere fact that it intersects with racism. But anti-poverty cannot replace anti-racism. All right, they can exist together and they should exist. Anyone else? Yeah.
It's medicine, so I like that data. Wonderful. And I'm noticing that many people here were not around during the height of the Jim Crow era. Unfortunately, I was around. I was old. And, so the idea, I knew a lot of poor people. I knew some Black people when I was a teenager. They were usually gardener or selling vegetables on the street. That's who you knew. And there were classes of people. But Black people were a totally different class. There's no comparison. The poorest white person viewed themselves as being superior to Black person. Sometimes I think that you have to go back to the Jim Crow, and, which I think is much more important than going all the way back to slavery and understanding racism.
Okay, very good point. So the point was that Blacks, whether they're poor or not, were placed in a different class, and that class was subordinate to even the poorest white people. I think there's a lot of historical support for that. In fact, Dr. King and other anti-racists would argue that racism among poor whites is one reason why we don't see this broader coalition of individuals struggling for greater economic justice. And one point on that is that after the civil rights legislation and the Great Society programs of the 1960s were passed. So I already talked about the Civil Rights Act of 1964, But the Great Society programs were really designed to, as economic justice, so it created Medicare. Also created Pell Grants, so scholarships for indigent people to attend colleges and universities. It expanded welfare benefits and created Medicaid. And so after that, we saw a great shift in white voters away from the Democratic Party because the Democrats are now associated with this economic justice legislation. And LBJ, who was president at the time, predicted that the Democratic Party had lost a generation of white voters, and that prediction came true. So I say this not to malign any particular political party because I think racism is nonpartisan. But because one party is more associated with economic justice, and I don't think they go far enough, I would force, at least for this moment, to discuss political parties and their role in preserving racial hierarchy. So, yeah, I mentioned earlier the demographics of who votes on programs, and I think that matters when we talk about elections as an expression of anti-racism or counter racism. But very good point. Historically, I think that was seen, and you see it now in some of the poorest white neighborhoods. So whites who live in poverty tend to vote for Republicans who will cut their benefits. All right, and I remember the Obamacare Medicaid extension, right? When Kentucky refused to pass the Medicaid extension, there were a lot of folks who said, wait, what's happening here? It's like, you voted against your own interests because, at least your economic interests, because your interest in racial equality is not strong. All right, so it's important to keep in mind.
Good evening. So I had a question about this when we talk about how we allocate resources to either a movement or just to right our own historical wrongs. How do we convince people in power at this point to give up some of that power? For example, Emory University, located where it is, has probably benefited from relocation of poor and people of color. The expansion of our medical system has probably displaced poor people of color. And historically, as a university, Emory has benefited from directly and indirectly from not only slavery, but also discriminatory practices. So what type of either direct action or indirect action campaign would be necessary to either convince a school like Emory or just anybody else in power to give up some of that power or remedy some of the past wrongs?
Okay, that's a very good question. So the question is, how do we convince powerful authorities, including those in Emory, to repair harms of the past? Well, a part of the speech that I cut out was things like social justice begins at home, right? So I remember when I was in law school, this was at the height of the anti-apartheid movement, and you had white students, the most vocal opponents of apartheid, disagreeing with students of color about racism in the United States, saying, well, we're pretty free here in England. And so we were like, that's not true. So why are you looking outward? Not that you can't look outward at the same time that you look inward, but I believe that social justice begins at home. And I actually chose to go to Emory because both the president and provost told me that they didn't get social justice as bulldozers. And I'm pretty sure I've worked at a number of institutions where that wasn't the higher education. So there are certain projects going on campus now that deal with trying to design remedies for some of the ways that Emory has benefited in the past in which there's inherited benefits that exist today, to sort of address those wrongs. So I encourage, you spoke extraordinarily eloquently about this. I encourage students to try to get involved with some of these efforts. This is like training for being a lawyer, to be able to get up and speak the way you did on this subject. So passionately, but also in a very informed manner. So I want you to get involved. I will let you say now, even though we're still designing this area of social justice, I believe there has to be a student component that involves supporting students in their social justice efforts. There are a lot of groups on campus to do that, and to involve students in providing services to the Atlanta community. All right, without that angle, I don't think we will be living up to our capacity with respect to social justice. And so that is one way that Emory, through this center, can contribute. And it also means continuing to demand that we get professors and staff who are committed to social justice. All right, so one way to do that, every year there's an appointments committee and there are student members of the appointments committee. Volunteer to be on that committee with the SBA because you have a role in determining who becomes professor. All right, so there are a lot of things I could discuss, but I want to validate your concerns and also argue that this is a moment for inspiration. All right, despite past failures, I think there is a tide that is turning. All right, and I believe that Atlanta is so different now than it was in the past. So there's a lot of community support for this. So, amen, and definitely join the Center for Civil Justice when it means nothing, right? Because students have a role in this. There's a hand.
I think
We're about to,
we're just gonna wrap up. Trying to see the people who are giving me that direction have left the room. Perhaps we'll close and then there'll be time as spent for business.
let me say, if you have a question that you want to get discussed, go to my bio on the school website, which has my email address on it. Send me an email with a question of the presentation. After this.
Well, please join me, everyone, in thanking